Everyone, my name is Tyrone Adams. I'm the CEO of the Colorado Association of Realtors. I wanted to first start off by just thanking you all for taking the time to join us today to learn about these important changes that will impact our industry. Before we begin, though, I have a few housekeeping notes. Today's webinar does not have CE credit, which is why we have disabled the camera feature for everyone. We're going to hold off on questions until the second half of the presentation. Once it is time for Q&A, please submit your questions in the Q&A box on your Zoom control. Unlike the first webinar we hosted on July 22nd, this session will not be addressing the contract changes related to the mandatory MLS practice changes. However, this webinar will be focused exclusively on the wide variety of other new contract changes. Today's webinar will be compliant with antitrust laws. Any questions submitted to the chat box that violate antitrust laws will be deleted. And any individual who continually violates the law will be removed from the webinar. So that's very important for you guys to understand that. Violation of antitrust laws include individual company policies, pricing, businesses, and customer strategies and or practices. An example of that is our company's minimum commission is X. However, if you wish to provide an example in your question that includes a commission rate, please do not enter a number. An example for that would be if I were to set my commission at X, how would I notify the sellers of my rate? If you have any tech issues, please submit that in the chat box and staff will assist you. This webinar will be recorded and shared to our YouTube channel, which is Colorado Realtors. CAR staff has created a page with resources about the contract changes and lawsuit update. So please go there, check that out. There's a lot of great information there. This link is also posted in the chat, and we encourage you to utilize this resource and pass along to your fellow realtors. Now, please help me welcome Scott Peterson. As you guys all know, Scott Peterson serves as our General Counsel for us, the Colorado Association of Realtors. We are the state largest real estate association. We represent over 26,000 members, over 28 local realtor associations, and I would be remiss if I didn't thank my member services team as well for collaborating with Scott to put this out there. Take it away, Scott.
Thank you, Tyrone. Good to see you, my friend.
You too.
I welcome everybody to version 2, or the second edition of this webinar series. I don't think we were necessarily intending to have a webinar series when we did the first one. It was very successful, but then we got a lot of feedback from everybody saying, hey, there's a lot of other changes. Can you do that? And so we had, kind of the ability to flip a switch and do this session now. And I'm gonna disagree with my good friend and boss on a couple things that were written into his script that I've kind of decided to modify this morning. And so it's this. One, as we're going through the contract to buy and sell, we're going to pull up the residential contract to buy and sell. I'm going to pull up the whole red line, and we're going to literally just go through it. And I'm going to be addressing the redlined sections. As I go through each redline change, if you have questions, go ahead then and put them in the Q&A as I'm doing it. And go ahead and ask, and I'll try and reflect after each change. When we did the session a few weeks ago, and I went through everything and went to the end, as you guys who were on that recall, we had hundreds and hundreds and hundreds of questions, and it just became a little bit too much. So I'm thinking I might be able to track questions as we go and keep us on track with the new contract. And then the other thing I'm going to say is this. I know I look at the Q&A now, and there's already one question that has to do with the new compensation changes and MLS practice changes. As I've been talking to brokers on the hotline and traveling around the state over the last couple of weeks, I know there are a lot of questions there. So when we get to the end of the red line changes, I'm gonna try and hang on for a little bit and handle some contract, or I should say MLS practice changes related to either the contract or best practices, et cetera. So, but please reserve those questions as I'm going through this until we get to that point and we focus on the specific red line change that I'm talking about as you're asking your questions here this morning. So I'm going to share my screen, which hopefully is a reasonably good size version of the contract to buy and sell real estate residential. We're going to use the residential contract. As you guys know, That's probably what the vast majority of the folks on my call are using. And I want to point out this. All of the red lines are available on our resource page, which links right to the Division of Real Estate website. So there's a number of other forms that are getting some changes. And then some of you have probably heard that at tomorrow morning's Colorado Real Estate Commission meeting, their regularly scheduled meeting, which is tomorrow morning, they're also going to be addressing 3 other contracts that kind of slipped through the cracks that needed some updates. And so I'm sure they will push those out after those are approved. It's the amend extend, the counter proposal, and then the residential addendum that you would attach if there was a residential component to either a commercial property or maybe a land contract, and there was some sort of secondary residential component to it. You would attach the residential addendum to either of those. Those 3 documents are going to get approvals tomorrow morning. There's nothing to talk. These are, most of it has to do with, because of the changes in this document that we're going to go over this morning, some paragraph numbers got off, some line numbers, there were some new titles and definitional kind of things. So there's nothing substantive that's being approved, but it does need to go through that formal process. I'm not going to touch on any of that stuff, but I would imagine by the end of the week, the red lines for those will be up and available for you. All right, so let's get going here. We look at the first page of the contract that's coming, and there's nothing new. Look at us moving to page number 2 out of 21 pages here. And this is an easy change. This home warranty red line, you'll see now at the very top of the second page of the contract, we have added 2.5.4. Seller and buyer are aware of the existence of pre-owned home warranty programs that may be purchased and may cover the repair or replacement of certain inclusions. As anybody who's been using the contract, that language was down, way down in the contract, maybe paragraph 10, much later on. And so it was just moved up to a more logical place here. If we look at inclusions, a home warranty that you guys are all familiar with those programs, those might cover, warranties that would be applicable for the personal property that are included, specifically things like dishwashers and other appliances, refrigerators, things of that nature. And so it got moved up, essentially the same language got moved up to a more appropriate place in the contract. I would say a higher profile place in the contract. And that's generally speaking a good thing. So I'm assuming there's no questions on that specific piece. If there is, that's not, will there still be transaction category? I don't know what that means, if you want to clarify your question. All right. So now we're talking about encumbered inclusions and leased items. And I'm going to kind of group these right there on the screen for you guys as we get to 2.5.5, encumbered inclusions and leased items. So remember, this is personal property that's included in the transaction. And these 2 categories, you ought to be familiar with them because you've been using them now for 2 years and 8 months since the last time the contract was updated. These categories, encumbered inclusions and leased items, were added to the contract in substance. And 2.5 here, encumbered inclusions and leased items, they were both right here in paragraph 2. What got added here is these paragraph, buyer will or will not, checkbox, assume the debt and obligations on the encumbered inclusion subject to buyer's review under 10.6. And buyer's receipt of written approval by such lender before closing. If buyer does not receive such approval, this contract terminates. And this down here under 2.5.8. Same thing for leased items. What are we talking about here? You guys understand this? In most situations, what we're talking about here would be solar panels. That's the easiest thing to describe. Sometimes when you get solar panels on the roof of a home on your listing, they're up there in 3 possible ways that I can think of. One is the seller or the homeowner purchased them outright and put them up. And that's more unusual because they're expensive. And there's good financing and leasing programs in place to amortize some of those costs over a period of time. Well, it's those second 2 categories that would invoke these. Encumbered items would be finance. A long-term financing agreement is put into place to purchase and have the solar panels up there, try and bring down sort of a monthly cost to a homeowner to offset maybe the savings they might get from their electrical bill. And the other possibility is that same agreement is structured as a long-term lease rather than financing. And so that's what's the easiest way to talk about in one of these 2. Now, these 2 new paragraphs that you see here, will or will not assume, those have been in the contract since 2.5 years ago, but they were way down in paragraph 10.6 under the due diligence. And this is a really good change in my view, because I feel terrible when I get the call on the hotline from a listing broker who says, oh my goodness, we're closing in 2 days. We got our settlement statements distributed, and there's a $17,000 offset to my seller's proceeds to pay off the remaining balance on the solar panel financing agreement or solar panel lease agreement. How can this be? And I have to then drag everybody down to paragraph 10 on the call to say, well, in the contract that your seller accepted, it said buyer will or will not assume the remaining financial obligations on the leased or encumbered items. And I'll say, well, what's checked? And of course, the seller's broker, listing broker says, well, it says buyer will not. And unfortunately, I got to say, well, that means that the seller will. In other words, it's going to be the seller's obligation to pay those off. And I was empathetic to some degree in the sense that the commitment, the buyer's commitment to assume the remaining balances on the lease or financing agreements was way down below this paragraph 2, way up above, where we were talking about these included items, these included personal property items like solar panel. And so they were completely disconnected and sometimes missed by the listing broker. That's a really cruddy position to be in as a listing broker. So now that these are tied together, I'm going to be much less empathetic when a listing broker calls and says, how did we miss this? Because they're right here. So language is the same, but now they're tied with this, with the inclusion of those leased or encumbered items, which is where it should have been to begin with. It wasn't. Now it's here. All right, Q&A on that. Any questions quickly on that? There are more commissions questions. All right, I'm not answering them. I'll get to the end. And by the way, guys, you can upvote the questions if you click on the thumbs up arrow. And when I get to the end and I'm answering questions, I'm going to answer questions based on what has the most upvotes. So you don't have to repeat the question. Just go ahead and upvote somebody's question if they've already got it. All right. Now we've got a brand new substantive paragraph here, 2.5.9, solar power plans. So this would be a situation now where, and we're seeing an increase in solar use, solar power, all probably good things, but there are agreements sometimes where somebody has solar on a property where they're essentially reselling through some agreement with some other utility provider, solar provider, energy provider, probably best way to say it. They're reselling the amount of solar that or the amount of energy that they're capturing, but not using on a particular individual property, and so they resell it to some third party. And this is where now in the contract, if you're homeowner, you take a listing, and that's the case. If they're subject to a solar power plan or solar power reselling agreement is maybe another way to think about it, with some third party utility or power provider, you would check this box and say, hey, we're invoking this part of the contract because it's applicable in our situation. So this is going to be when you sit down with your sellers and list the property, you're going to be asking them if they have solar, particularly if they have large grid kind of solar stuff and they've got any agreements to resell any of that energy. You're going to be asking them if that's the case. If they do, you're going to want to make sure when you get your offer that this box is checked here, calling this out. And it's essentially the seller now disclosing, hey, we've entered into a solar power purchase agreement, regardless of who that's with. We authorize some third party to operate and maintain a photovoltaic system. I didn't come up with that word, but on the property, and provide electricity, solar power, will remain in effect after closing, because these agreements typically are going to survive closing, and absolutely the case if the solar panels that are being included in the paragraphs above are staying with the property. And here's where we get to the commitment. Buyer will or will not assume seller's obligation under such plan, subject to buyer's review. Under 10.6, the solar power plan, and that's where, when we get down to due diligence, I'll point out where this comes up again, and buyer's receipt of written approval by the third party before closing. So what that means is the buyer is going to assume the obligations remaining, or they're not, in which case it's going to be the sellers. If the buyer will not, seller's going to have to figure out how they're going to unwind themselves from the solar power plan prior to closing the property. If it says buyer will, then the parties are going to have to submit the buyer to this third party, this solar, whoever's the power provider that is the other party to the plan, and they're going to have to basically assign that contract. They're going to have an agreement, the agreement amended to now name the new buyer as the party, and that'll have to be done at closing. And if for some reason that agreement isn't assignable or it can't translate, that can't be moved, it isn't moved, then guess what? If they don't get such approval, this contract terminates. So it's kind of an automatic termination feature built in. Are propane tanks included in leased items? Yes, that would be included in leased items. What if neither box is checked? If neither box is checked, when you say neither box, are you talking about buyer will or will not assume? Or are you talking about the existence of leased or encumbered items? If neither box is checked, then guess what? You've got what I refer to as a contractual ambiguity. I don't know who's right. Ultimately, that's a broker problem. That's who's wrong, is the two brokers who allowed a contract to be executed mutually by two parties with an ambiguity in it. And so somebody's going to have to figure that out. So if you're not checking will or will not in either of those boxes, then it's ambiguous. The contract doesn't say who's going to assume those responsibilities. And now you guys as the brokers are going to have to figure that out between the two parties. So please, if there is going to be a remaining balance left on encumbered or leased items, make sure that you are addressing that and who's going to be paying it off. So we have to check both leased and encumbered. No, leased, if the solar panel agreement that your seller has with the solar panel company that put the panels on the roof, if that is structured as a lease, some sort of a long-term lease agreement of the solar panels, you would check lease. If that is structured as we're buying them, but the solar panel is going to carry back debt, they're going to finance them out over 15 or 20 or 25 years, whatever that might be, you would be checking encumbered. So there's a difference between how those agreements are structured depending on the solar panel company, depending on the agreement that your seller entered into. So you're going to need to make sure your seller understands what they have, and then they're going to be including it based on whether it's encumbered or whether it's leased. Does this count if the solar power company pays them back for any overage once a year? That would be part of the solar power plan. If there's some agreement, then that's going to need to be addressed. So the answer is yes. What if both sides miss will or will not? I already checked that, or already answered that. That's a broker problem because it is a problem for both the buyer and the seller, which means what, guys? It's a problem for the brokers. So make sure you check somebody. If a seller has solar on their home and pay a monthly payment to the company, is that under 2.5.9? Correct. Again, if solar's on the home, it's going to be up there either A, because the homeowner purchased the whole thing, installed it, and they own it. You don't need to worry about this. Okay, this would be included personal property even further up in paragraph 2. But if the solar is up there because there is still an agreement in place between the homeowner and the buyer, or excuse me, between the homeowner and the solar company who put the panels up there, that's where you need to figure out if it's a financing agreement or a long-term lease agreement. Will there be a new field on the MLS indicating whether the property is participating in a solar panel plan? That'd be a question for your MLS. Might be a good idea to figure out so that the buyer understands that when they're writing the offer in most cases, and so that the seller or listing broker doesn't have to counter an offer to disclose that. So I would encourage it. We've got 13, 14 MLSs in the state of Colorado. And so whether or not they add that field, some of them probably already have it. I just don't know. If buyer doesn't have approval by a third party one day before closing, then they can still terminate and get their earnest money refunded. That would be correct if the buyer doesn't have approval. So in other words, if you're a seller and you've checked this box, then you need to be working with your relationship, which is with the solar panel company, to make sure that they're getting the approval done prior to closing. Otherwise, yes, the buyer would have a right to terminate that. Does this revert any income that the seller may be receiving? Yes. Please use upvotes if you would, guys. That would help me. If the contract terminates because a third party doesn't give approvals, does this mean the buyer is subject to the return of the earnest money? The buyer would receive their earnest money back. And we're going to come back to this concept of what termination means in a later change that's in the contract, paragraph 25. So yes, they would get their earnest money back. The agreement for the current owner has with, oh my goodness, you guys are complicating this, I think. Maybe this idea of me trying to take questions as we go is too much. Can this be made and deliver an objection deadline? No. Are you talking about another party than the main power company? I'm talking about if there's any solar panel, a solar power plan in place, that would be a third party agreement. I'm not talking about Excel Energy if you're just getting electrical utilities. This has nothing to do with that. This is solar. Obligation is the payment plan for the lease, loan, or the terms of the plan. The solar power plan it's a third-party agreement with a solar company that where they're purchasing power. Whatever those terms are, that's the agreement. Those terms could all be different. It doesn't really necessarily matter what those terms are. It's that an agreement that the seller, homeowner, has with some third party. Whatever those terms may be, it doesn't matter. If there's a third-party agreement related to the resale of solar, this box needs to be checked. The terms of the agreement we're going to get to in paragraph 10, because that's when the buyer is going to have an opportunity to review it. If there are no panels, then these don't apply and boxes checked. If there's no panels, it's not just panels. Solar panel is the most common. You could have encumbered inclusions, might be an alarm system that's in place. Encumbered or leased items could be a variety of different things. It's just most commonly. So the question for your seller is there any personal property that's going to stay on this property after you close that needs to be paid off at closing? Solar's the big one because those are generally big numbers that everybody needs to be on the same page. But it could apply to any agreements with third parties for any personal property that could be included. I've seen water softening systems, something like this. I've seen, like I say, alarm systems could be subject to some longer term payment plan. If any of those things apply, then these would need to be checked. Solar is the most common. Oh, you guys. All right, I'm moving on. Done. Again, if there's any questions I didn't answer, it's on you guys to upvote those questions. And when I get to the end, I'll be making sure I return to these things. All right, now we're moving. Here we are. We're on page 3. You can see here, pretty nominal change. Just remove the word certificates. Water stock could be transferred to a share. Certificates. Certificates is, I don't want to say superfluous, but it seems too confining. So if there are water shares, water stock, it's going to be transferred at closing, then you would enumerate that there based on the property. If you don't know what these things are, I'm going to guess you probably shouldn't be doing deals from a competency standpoint if you're talking about water stock without some water rights competency. And then this is another nominal change, but I want to point this out because it's going to come up a number of times. So the forms committee, and looking at the forms, realized that as we've had this, buyer does not have a right to terminate if examination of water rights is unsatisfactory to buyer before the water rights examination deadline. That language was already there. So if you look down here, and with any of the dates and deadlines, including water rights examination deadline, if you want this to apply, right, then if you want this to apply, this water rights review, you shouldn't have to check does or does not apply. You would simply put a date or deadline in water rights examination deadline. And that's what invokes it. And so what I think the forms committee looked at as they were going through the contract, they realized there's a number of places, and I'll point them out as we get there, because as you'll see the other areas of redline. The way to invoke whether the buyer does or does not shouldn't have to be by checking a box, does or does not. It should just be by putting in a date or deadline to invoke that contingency. And by invoking that contingency, it gives the buyer the right to terminate based on that termination right by that termination or examination, in this case, deadline. So that's why that changed. Not substantive, but I want to explain that because I'm not going to re-explain it as we get to some of the other areas where I'll point out that same concept. Look at us, paragraph 4, just flying through like nobody's business. I'm sure many of you are happy about that. Oh my goodness, nothing on page 4. Here we are, page 5. Looky here. All right, this is just a paragraph update because now, as we know, paragraph 29 in the contract is the last completed paragraph. That's the buyer broker compensation section, and we'll see that at the bottom, but we won't talk about it, right? That's our deal. Unless we're done with this portion of the class, then I'm happy to re-entertain it. But now it's paragraph 30. So the additional provisions used to be paragraph 29, it's paragraph 30. That's all that change indicates. Now, let me point this out. This is related to some of the compensation stuff. Loan limitations. So this has been there, but it got a sentence added. And would be where you check for this purposes of this sentence. This is where you check FHA or VA in the loan types. And then because of some of the compensation changes, we added this sentence that says that this maximum amount that a seller may be obligated to pay on a VA or FHA loan on behalf of the buyer is capped at this dollar amount, whatever you're going to put in there. So you've been doing this for years if you're doing VA or FHA deals. If you're given that loan contingency, if your seller's given that loan contingency, then you're putting a cap there. And this is just to clarify that whatever that cap is, it doesn't include any compensation to be paid to buyer's broker's firm. Okay. Now, the easiest way to explain this is, as all of you guys know, VA has a rule, and it's currently just not being enforced. So the rule is technically still in place that says, a VA borrower, a borrower who's taking advantage of a VA loan, they're not allowed to pay brokerage compensation to their buyer broker. All right, that's what the rule says, and it's been a long-standing rule. Now, since all of the practice changes went into effect and were announced back in mid-March, VA, the Veterans Administration, and I think through CFPB and kind of the lending arms of the federal government, what they decided after a lot of lobbying from the National Association of Realtors, frankly, they decided that they're going to suspend enforcement of that rule. And my assumption is, because as we were all dealing with when these practice changes came out, it's like, well, if a VA borrower they're not allowed by the loan limitations to pay their own broker, then how are they going to have representation if they have to do that? How can they commit in an exclusive right to buy to pay their broker if they're legally not allowed to do it? Well, in order to accommodate the changes in the practice and to enable them, if they are in a position where they need to pay their buyer broker, the VA came out and said, we're suspending enforcement of that rule pending a more permanent rule change. So my guess is over the next 12 or 18 months, federal government's going to make a formal rule change that's going to allow the VA borrower to pay. But currently, as it's currently sitting, they have said that is fine because we're not enforcing that rule until we make a more permanent change. And so this sentence got added basically to clarify that whatever cap here, in the event that in the event that the seller is agreeing to pay the buyer's broker pursuant to this contract in paragraph 29 that we'll talk about, or we won't talk about later, we may talk about later, pursuant to paragraph 29, this has nothing to do with that. This is only the additional cost that is not uncommon in a transaction where a VA or FHA buyer is not allowed to contribute to those areas of the closing. All right, this is just some line spacing issues. I don't even know why they left that, because there's nothing changing. The line spacing got screwed up. All right, now this is under assumption here, 4.6. This was added as well. This contract terminates if written consent from seller's lender for buyer's assumption of seller's existing loan is not received by all parties in the closing company on or before closing. So this is another automatic situation. We are seeing an increase in loan assumptions around the state. Again, primarily kind of VA, primarily in VA, but VA FHA deals might be assumable, or generally are assumable. And because of the high interest rates, we've seen a lot more sellers that are willing to extend the assumption of their current lower, in most cases, interest rates that they've locked into to allow a buyer to assume that loan from them. It's a very nice marketing benefit, frankly. There are some wrinkles, though, making sure that the VA borrower is, if whoever's going to assume, the new buyer is going to assume that loan, if they're not a veteran, then the original seller's VA benefit is still hung up in the loan that's being assumed. If they're a veteran, it goes away, but do be careful of that. The point of this sentence, though, is contract terminates if there's not consent for the assumption. Obviously, the lender's got to approve this assumption, and that's all got to be distributed to all parties in the closing company before closing. Otherwise, contract terminates. What happens at termination? Buyer gets their earnest money back. So if you're doing an assumption deal, you as a seller are pretty darn well incented to make sure that that process is moving along in a timely fashion in connection with the closing to make sure that gets done. All right. And then we kind of put assumption into this financing conditions down here that normally has been applicable to new loan. I want to point this out because I've had a couple of people point this out to me. So on both of these, they remove this if an existing loan is not to be released at closing, and in credit information if an existing loan is not to be released at closing. So those are gone. Now, some pretty astute people, frankly, pointed out to me that if you look at paragraph 5.3, with that clause removed, and you just have paragraph 5.3 credit information, and it begins, this contract is conditional for the sole benefit of the seller upon seller's approval of buyer's financial ability and creditworthiness, and so on. What I've had pointed out to me, and I've got some concerns about how this might be in place, but as this is now drafted, 5.3, if a seller were to put a date or deadline in the dates or deadline, or counter an offer with the dates or deadline up here, and include credit information deadline, wherever it's at, right here, buyer's credit and disapproval of buyer's credit information deadline. The way this paragraph is now drafted, and I don't want to say this was the intention, but it could be the effect, is that a seller could negotiate into the contract for their sole subjective benefit what I would argue would be the most powerful seller contingency of all. It's basically saying, hey, if forget about the type of loan, or if there's an assumption, or if there's any seller financing, by that credit information deadline, the buyer has to submit to the seller, per the terms of 5.3, all of their information and documents, a current credit report concerning their financial condition, employment, and credit condition. And the buyer gives the seller the right to verify the buyer's financial ability and creditworthiness. And any documents received by seller must be held in seller's confidence and not released except to protect seller's interest in the transaction. So this is not what I'm encouraging anybody to use it as, but it is a wallop of a contingency now. If a seller says, wait, I'm not going to accept this contract from you, buyer, until you provide me, even though I'm not going to finance anything for you, and even though you're not assuming any loans to be paid off of mine, I just want this pre-approval letter from your lender is not enough for me. I want all of your credit employment information. And again, that was not the intention of that paragraph, but you need to be clear, buyer brokers, if you're getting a counter offer from a listing broker that basically adds a date or deadline now to buyer's credit information deadline and disapproval of buyer's credit information deadline, what your buyer will be committing to is basically providing all of their credit information, employment information, credit condition information to the seller in connection with just a regular contract. Maybe it's a cash deal. Maybe it's a conventional loan. Now the seller's going to have the ability to review that, and in their sole subjective discretion, if they, with the disapproval deadline, terminate the contract based on, I don't like what I see there. I would not encourage sellers or listing brokers to be using it in that way. That is sensitive information that I'm concerned. You know, we've got our personal identifying PII statute in Colorado. We have very, very stringent rules related to somebody receiving another consumer's personal identifying information, including social security numbers, you know, credit card, debit card numbers, driver's license copies, and Colorado ID copies. It's a very expansive statute that is very, very restrictive and creates a lot of burden and obligations on anybody who's receiving that from another consumer in Colorado. And this could invoke a lot of that. As a seller, you're not in a place where you're probably able to really review and consider the buyer's credit worthiness if you're not having to provide financing, seller financing to them, or if you're not relying on them to have the capability of assuming your existing loan. And so I'm not sure how this is going to play out, but I would point out, be aware that credit information could be used as a standalone deadline, and maybe in a multiple offer situation, the seller says, well, I got all these offers. If I'm going to accept a contract, then I want to be able to really scrub the buyer's credit information. Again, that was not the intent, but as this is currently drafted, that certainly could be the impact. And be aware, I am not encouraging listing brokers or sellers to use it in that manner. But if for some reason you're a buyer broker, you make an offer, seller counters with adding 5.3 or buyer's credit information deadline and disapproval deadlines, then understand what that's going to cause your buyer to be delivering to the seller. And if you're a seller or listing broker who's receiving that stuff, be crystal clear on the requirements of the personal identifying information statute in Colorado, because it is rigorous. So anyhow, that little clause being removed has the potential for impact. 5.4. Do I even dare look at the questions at this point? Yeah, 5.3, given the credit information and the deadline, I would think we want to put a date within 7 days. Again, I'm not encouraging you or your seller to receive and expect to review that stuff. But yes, 5.3 was initially for owner carry or assumption. That's for a situation where the seller is incented in the normal, in a deal because of the financing agreed to. Again, seller carry financing or seller financing and or buyer assumption of the seller's loan, the seller wants to make sure, hey, the buyer's in good shape. So I'm saying that with the removal of that little caveat at the beginning of 5.3, I can see it being used. Does seller have recourse against mortgage company that does not honor an assumption, even though the assumption was sold? I doubt it. You're not going to sue your mortgage company if for some reason that your lender decides they're going to deny the assumption. If the information is provided to the seller, whose responsibility is it to obtain the info and from where? I mean, it's the buyer's obligation, according to that clause, to deliver it at buyer's expense. And in terms of maintaining it, this is where I get into some real serious concerns about if your rank and file listing broker and seller, homeowner, consumer is in a place where they understand their obligations in terms of confidentiality and maintaining the security of that information that they're getting. You're saying that the seller is in a position to review finances in any situation. I thought this, again, I'm pointing out that people have pointed out to me that removing that clause creates 5.3 as a potential standalone seller contingency clause that could be invoked. If your seller's going to use it, make sure they understand the implications. If the buyer is getting a counteroffer with that in, make sure your buyer understands the implications and what their obligations are going to be. Can 5.3 be deleted? Yes, 5.3 can be deleted by leaving it blank, which is what everybody's been doing it in 99.9% of the deals. If you don't put a date or deadline in the dates and deadlines, that, because of what it says in paragraph 3.2, it automatically deletes the whole paragraph. So I'm encouraging you guys to continue doing that. I'm just pointing out a nuance that has been pointed out to me by a handful of people, and we'll see how this plays out. Yeah, I'm moving on. Thank you for whoever agreed or encouraged me to. Existing loan review, it's been removed as well. This is not something that if you're not doing an assumption, then there's no reason to put a date or deadline in there. So the consequences of removing those first words on 5.4, I think nominal. The consequences in 5.3, potentially more significant. Another easy change, just moving something, essentially the language from much later in the contract up here in terms of this representation. Buyer represents that buyer will occupy the property as buyer's principal residence unless the following box is checked. Then buyer represents that they will not occupy. So if your buyer is going to move in, it's going to be their house that they're going to live in, closing it to move in and be their primary residence, you're not going to do anything. But the buyer's making an affirmative representation by signing the contract that that's their intention. To the extent that that's not their intention, then they need to be checking that box. If that's not their intention and they're not checking that box, I would argue that buyer is entering into the contract in bad faith and could have its own set of default implications. So this was all done down much further in the contract, and I'll point out where it was deleted. It just got moved to what the Forms Committee felt was a more appropriate place for that representation. All right. We're scrolling, friends. Look at this. Nothing to worry about. All the same, all the same, all the same. This is exciting. Now we're making progress. All the same. Oh, here we go. This is an easy one, though. 8.9. This is another situation. Like I remember I talked about above with the water rights. So again, if the buyer in their offer needs to or wants to examine any mineral rights, potential mineral rights, and they want the ability to terminate upon that examination, if they don't like what they see, then they shouldn't need to check a box does or does not. It's superfluous. All they need to do is put up in paragraph 3.1 in the dates and deadlines chart, they need to put a date or deadline for their mineral rights examination deadline. And what that means is the buyer does have a right. If they don't put anything there, then they don't have a right. So this is just making it consistent and not superfluous in that way. So we talked about the implications of that. That's not a substantive change, but just another situation where trying to not be superfluous, I guess, in the contract. Okay, 10.2. This is, they're modifying what is literally, I think, my favorite sentence in the entire contract to buy and sell. Except as otherwise provided in this contract, buyer acknowledges the seller is conveying the property and what was added and inclusions to buyer in an as is, where is, with all faults condition, or as is condition, where is, and with all faults. So it used to just say the property. The property always, I think, implied, everything with it. But again, trying to be clear whether it's the property itself or any inclusions, including personal property, appliances, solar panels. Hey, buyer, when you close, you're getting what you get, and seller owes you nothing, with the exception of the seller has to disclose in writing any adverse material facts that are actually known to the seller. So otherwise, it's an as-is contract. Always has been in relation to the property. It's always been implied, I think, with relation to any of the inclusions, but we added inclusions to be even more clear about that fact. Not a lot to think about there, but it is now more clear, I believe. All right, friends, we're down into paragraph 10.6. So this is all the due diligence stuff. And you can see 10.6.1.2 and 10.6.1.3, where we moved these checkboxes, buyer will or will not assume seller's obligation under the leased items, or will or will not assume seller's obligations under the encumbered inclusions. These sentences are now up where they belong in paragraph 2 in the inclusions section of the contract. So they're deleted here now, okay? This is what I was talking about before. These boxes sometimes, and I got way too many hotline calls for this to be acceptable from listing brokers who didn't understand what this meant or how it was tied to, again, in my example, the solar panels. But it's all now together, and so it makes it much more cohesive for the seller to consider and hopefully not miss. If the buyer is expecting the seller is going to pay off the remaining balances on those things, it's not something they want to miss, particularly if the seller doesn't intend to. All right, now here's your solar power plan. So remember, we talked about solar power plan above, and that's where they're checking the box. The buyer will or will not assume any obligations, and they're going to transfer the obligations in that solar power plan. Under due diligence, though, is where you would be delivering that. So in connection with all of the due diligence delivery deadlines is when a seller would be giving to a buyer, if not earlier, a copy of that solar power plan. Remember the agreement that the homeowner seller has with some third party related to the resale of additional solar energy. Okay. So this is where it's going to be delivered in connection with your due diligence deadlines. That's where it's going to be reviewed, considered by the buyer, objected to, and terminated. All right. All right. This is a brand new one as well under due diligence. And, this is tough because in Colorado, I think we have 64 counties in the state. This is a commission approved form. It's written, meant to be used in 64 counties. And septic, as you all know, that's something that it's not a statewide requirement. It's a county by county requirement. Some counties don't really do anything with septic. They just don't worry about it, or they don't have a lot of protocols or permitting or use permits or anything in place. An increasing number, I would say, certainly do. And so this is where, if required by local health department or other applicable government entity on or before the local health department's applicable deadline, seller must pay for and furnish to buyer a septic use permit. So if there's septic on the property and it's in a county that has countywide requirements related to that septic, this is now something that is in the pre-printed form that the seller is going to be obligated to figure out and do what they need to have done. Often it's a solar inspection, a septic inspection, but make sure that that is going to be done in connection with the transfer of the property. So if you're doing, this is part of your geographic competence, I would argue, under our commission rules. If you're doing properties that have septic and they're in counties that have implications to the transfer of that septic or the septic use permit, you're going to have to be aware, whether you're on the buy side or seller side, what needs to take place and when. And it's now enumerated there in the due diligence guidelines. So that's essentially what that means. And then there's this automatic due diligence extension. I'm going to go up here to the questions at my own risk of peril. How old can the permit be? All rules related to septic are done by the county where the property is located. So I don't know what they might have county by county. Does seller need to get septic up and running? That's an agreement of the parties at its threshold. A seller can sell to and a buyer can buy a property in pretty much any condition that it's in, as long as whatever bad conditions it's in are disclosed to the buyer. One of the limited areas where that might not be the case would be if you've got a county with very rigorous transfer of property requirements as it relates to septic. So this is what I'm talking about. Is the question is appropriately for your county. If you've got a property that has septic it's where the property is located. And so, in Boulder County, because of the backlog, we sometimes don't have septic smart certificate in time for closing. Having it due by the due diligence deadline is a big burden on the seller and may not be realistic. It's not that it's due by the due diligence deadline. It needs to be, what it says is, if required, it needs to be done on or before the local health department's applicable deadline. And so it falls under due diligence delivery. All right. But it's not, you don't deliver the use permit. The use permit is tied to whatever your local health department. So I don't think this has an impact like on Boulder. If they're behind, then clearly that Boulder Health Department's applicable deadline is later than closing, if that's what they're doing, because they're delayed or for whatever reason. Under DDD, the buyer requests seller. I don't know what DDD is. Maybe I'm just not thinking, but I'm sorry. Some counties require a party to agree to have it up and running within so many days of closing. That's exactly it. Everything is different, but this is now calling it out. This is not something that you shouldn't have been aware of before. It's just now going to be in the contract to make sure that we're addressing whatever the county needs to have done. It didn't appear in the contract before, and it's a pretty fundamental thing that needs to occur. All right. Oh, DDD due diligence documents. So what was my DDD question up there? I don't see it. All right, I'll try and ask it again. And again, upvote guys if you have. Oh shoot, I don't want to close out of my Zoom. All right. Automatic due diligence deadline extension. So this was added. This is new. If a due diligence document is not delivered on or before the due diligence document's delivery deadline, buyer has until the earlier closing or 10 days after their ultimate receipt to review and object to such due diligence document. If buyer's right to review and object to such due diligence document is extended due to that late delivery, then the due diligence resolution deadline will also be extended to the earlier closing or 15 days after buyer's receipt of the documents. So it's kind of a 10 days, 15 days. All this is an automatic situation where, and we've got a number of these clauses built into other areas or sections of the contract, including CIC documents, including seller's property disclosure. And so nothing new here, but it's basically, hey, if you've got a due diligence document delivery deadline and the seller, for whatever reason, doesn't give to the buyer the solar power plan, the agreement that we just talked about that's under due diligence, then they deliver it 3 days later, then the then that buyer then has 10 days after the seller delivered it to him, or closing, whichever is earlier. So if closing's in 5 days, then obviously they got closing, right? But if closing's in a month and they deliver it, then they've got 10 days after their actual receipt. And then similarly, the due diligence document resolution deadline would be extended by 15 days, or closing, whichever is earlier. So that's all this is saying. Shouldn't be too earth-shattering or difficult, I hope, but I'll leave that there unless there are questions. Every time, it's funny, I get this like true apprehension every time I open the question box to see like, oh my God, how far behind could I have just gotten? If seller, where did I leave off? If seller does not have any due diligence docs to avoid the automatic extension, seller must provide a notice, or must they provide? No, I mean, if there's nothing to deliver, there's nothing to deliver. Communication, Jay, is, as you know, never going to hurt anybody. I would probably be clear with that. If there's no due diligence documents, you could also counter the offer and just remove the date or deadline. Or remember, then all of that stuff goes away. But I like communication, but basically it's a matter of if there's something to deliver. But if you're not going to deliver anything, I would probably, as a broker, send an email to the other broker, or here's how I would handle it. I'd send an email to my buyer saying, hey, buyer, just want to confirm you're telling me you don't have any due diligence documents that are applicable or appropriate to deliver. Buyer says yes. And then I would probably send an email then to the listing broker, or excuse me, buyer's broker, to say, hey, I just confirmed with buyer, we're not delivering any due diligence documents because they're not applicable. This was the question. Under due diligence documents, if the buyer requests from seller receipts for items $500 or more that seller has, and the seller comes over for an inspection will that I don't think so. I mean, no. So I'm trying to, I don't think so. No. I mean, so the question is let's say that it's any receipts over $500, and then there's a $2,000 electrical panel replacement, and then the buyer is giving the receipt, or excuse me, the seller then is under the due diligence is giving the receipt for the $2,000 the buyer just used. No, I don't think so. That's not going to reopen your due diligence documents deadline because you're delivering that late. I mean, that's going to be delivered probably pursuant to an inspection resolution that says, seller to have replaced the electrical panel and to provide buyer with a copy of any receipts. So that'd be some serious shenanigans if the buyer was trying to weasel out of the contract in some way related to that. Seller's standard contract language does not specify that the due diligence doc only include those in seller's possession. I talked about this in my 10 things class last year. This is one of my 10 things. You got to make sure, for those of you who are adding that whole blue paragraph of ink, at least under some forms contract providers, it's all blue. And it's like, seller's going to give to the buyer everything, any receipt for $500, anything, everything, all reports, inspections, blah, blah, blah. Everybody on this call knows exactly what I'm talking about. Listen, if you're going to allow your seller to accept an offer that has that, I won't say it, but silly clause in it, you got to make sure that also contains language that says in seller's possession. Because otherwise, the seller, if they just agree to deliver all this stuff, they're going to be out finding, inspection reports or, every receipt under the sun and everything else. It's in seller's possession is absolutely critical to this question here. I don't love that clause, but whatever. I mean, if you accept it, just make sure it's limited in seller's possession. And if you're a listing broker and you're getting an offer with that big blue ink clause in it, point out to your seller, make sure you're flagging for them, that they need to be mindful of any of those things that they might have in their position, and they need to deliver it to you so that you can deliver it to the buyer on or before the due diligence documents delivery. I think the sentence seller must furnish and pay to furnish buyer septic use permit indicates a septic smart certificate does need to be delivered by the due diligence deadline. Well, it says in 10.6 that it needs to be delivered pursuant to the county's requirements. How does one prove or enforce that a due diligence doc has not been delivered, being buyer doesn't always know? Stop writing that clause. That'd be a good way to do it. Can buyer require that closing be extended? No, that's an amend extend. Anytime you have a contract and you're going to try and amend it, you got to have two parties agree to do an amend extend. So, buyers don't have some magic ability to require that it be. Now, if sellers agree to do something prior to closing and they don't do it or can't do it, then guess what? Seller's in default and buyer has all of their remedies under the default clause. But you can't require somebody extend something. Can you confirm there is an automatic extension for seller's disclosure? I think it is if there's items that come up or disclosed after the seller's property disclose line. I think it's 5 days or closing, whichever is earlier. It's in paragraph 10.2, I think, maybe 10.1. Does the automatic disclosure apply so that a buyer could object to the due diligence for all due diligence or just one document that is received after? No, I mean, if there's an obligated document to be delivered and it's delivered late, then they could object to that document, not to all items, but it's still going to be in the net effect, the same extension of that due diligence. So what does that mean? It means for listing brokers, if your seller's accepting a contract that has due diligence deliveries in it, get them delivered on time. If you don't, you're exposing, get all of them delivered on time. Don't deliver 9 out of 10 of them and then deliver one of them late, because that one of them late would give the buyer the ability then to invoke the extension language with regard to that. First attorney who's ever expressed such stress. I don't know what yes, I'm high anxiety right now. I'm not sure what I was expressing stress about. Maybe you're talking about the due diligence stuff. But anyhow, I'd love to have you clarify. And sorry if I seem stressed. It's hard for these questions as they're getting asked, it keeps pushing things up. So I'm doing what I can. If seller does not have requested due diligence documents, is the deadline date extended? If they don't have them, they shouldn't be required to deliver them. Okay, that's why I was saying it's so important to make sure you have in there. The due diligence section does not say that the seller will deliver what they have in their possession. I agree. It does not say that. So whatever is in the due diligence needs to be delivered by seller in connection with that deadline. What I'm saying is there's also that blank, and it's in 10.6 point whatever here. Other documents, 10.6.1.6. What that says is that's where you get that long laundry list of blue ink that buyer brokers looking to really show their value to the buyers. That I have seen those clauses that have either by intention or error, those typically, the standard clause that I see there will say in seller's possession. But I have seen a number of cases where, for whatever reason, those words in seller's possession has fallen out of that. And you're correct, Molly, to the extent that a seller accepts a contract that has that long blue litany of stuff and it doesn't say in seller's possession, then what applies is seller's got to deliver all of that. All right. Is in seller's possession include listing agreement, include listing agent, has it because seller bought it a year ago? Yes. I mean, if you have it in your possession as a listing broker, I think that's as good as a seller having it in their possession. I wouldn't mince. I mean, if you have some documents in your possession that your seller doesn't, but you do because you closed with your seller when they were a buyer a year ago, I think those are things that you probably want to make sure your seller have access to so that they can comply with the terms of the contract. Septic. There's on occasion a buyer who agrees to install a new septic system at buyer's expense. It is almost always someone buying a fix and flip, lowballing the seller. That aside, this section seems to imply buyer can no longer order and pay for the septic installation. Boulder County has specific language that buyer and or seller is responsible for the septic being in compliance. Again, if required by the local health department or other applicable, on or before the local health department's applicable deadline. So again, if whatever has been agreed to in septic regarding septic has been working in your county to this point, I think that this contemplates that it will work again because it's on or before the local health department's applicable deadline. So if the local health department will allow a property to close and then after the fact, seller to replace the septic system, then that would still be in connection with the local health department's applicable deadline. Otherwise, the local health department wouldn't allow the property to close in that situation. So, here's the thing with these contracts. Every time we release, every 3 years when these get released, what manifests is a handful, often, hopefully a small handful of items. And a good example is 3 years ago when we added to the due diligence, the buyer will or will not assume any remaining balances on the seller's included personal property. And that was down in 10.6 rather than in paragraph 2. It could have been done better. So I think this works. This was written as broadly as possible to allow for all of this to continue in what has been working within your county. This is just identifying, calling out that in counties where there is some use permit required, then honor before the local health department's applicable deadline. Again, that's what expands it. That little clause right there expands it to, I think, work in other places. Yeah, some people want questions limited. All right, I'm gonna move on. Thank you, Crystal. I agree with you. Okay, did we finish this? Yes, we did. The automatic extension. Look at this, we're making progress. This is an easy one. I shouldn't have any questions here. Closing, 12.3. Delivery of deed from seller to buyer will be at closing. Yep. Closing will be on the date specified as the closing date by mutual agreement or by mutual agreement at an earlier date. At closing, seller must provide buyer with the ability to access the property. That's what was changed. It used to say seller agrees to deliver a set of keys to the property to the buyer. Obviously, in the last 3 years, we've had an explosion in the little, keypads and all the little stuff, other ways, the phones and all the other connections. So now it's same concept. Even if there's a post-closing occupancy agreement, right? The seller at closing, because that's what it's tied to, is obligated to deliver access to the property to the buyer by whatever access is appropriate based on that situation. All right, 15.3.1, status letter fee. Check boxes are gone here, and I'm in agreement with this. And when we get to the next change, I'll point out where I wish we would remove check boxes as well. Any fee incident to the issuance of the association status letter must be paid by seller. And that to me makes sense. If you don't like it, take it up with the Division of Real Estate and their forms committee. But it's now defaulting status letter fee is seller. But let's talk about this now, 15.3.3. So this was a nightmare. This paragraph is currently until August 15th, so for another 10 days or so, assessments, reserves, or working capital. This assessments word was really intended to be assessments that are paid in advance. Some associations refer to their reserves or working capital as assessments that are paid in advance. And 3 years ago, when this word to contemplate, remember, we've got over 10,000 HOAs in the state. So trying to write a state form contract and to make it so that it makes sense, it doesn't always make sense. So that assessments word really confused people with just down here, 16.2, association assessments. So this has been cleaned up and hopefully is now clear. 15.3.3 is going to come over on the status letter, and it's going to say there is this deposit, essentially, that the buyer, in my opinion, it should always be the buyer, needs to bring to the closing table for the buyer's reserves or working capital. Okay. Reserves or working capital is a much better way to think about it than assessments or assessments paid in advance. But some HOAs, they have in their governing documents the requirement that every homeowner that owns a property in that HOA has on deposit $1,000 or whatever dollar amount it might be. And that is in case there's some emergency, some big curveball. So they have in their reserves this corpus of funds that are held on deposit for the benefit essentially of the current homeowner in that HOA. So this now just says, unless agreed to otherwise, all reserves or working capital or other similar cost not addressed now. So not regular or special assessments. It's something that would come over on the status letter, not addressed in 16.2. must be paid at closing by buyer, seller, one half, or not applicable. Buyer should be checked there. Buyer should be checked there every time, unless the seller is as a concession to the buyer. Maybe the property's been long days on market and their seller's saying, I've just got to get this thing sold. I'm even willing to pay for the buyer's reserves or working capital that are going to benefit them during their period of ownership after I close. I'm willing to do that. Unless the seller's eyes are wide open on that issue, it should be buyer. That is money for the benefit of the buyer to be held by the association during their period of ownership to deal with curveballs on the property or on the community areas of the property. And so I wish we'd remove the check boxes. We didn't, but it should be buyer unless the seller's eyes are wide open about it. Don't screw that up. We've had a lot of that over the last couple of years because of confusion and otherwise, and sellers end up being ticked because they have a debit to their proceeds at closing to fund the buyer's reserves and working capital that they're going to enjoy the benefit of during the buyer's period of ownership. I'm sure that probably invoked a lot of questions. I don't even want to see them. Here, again, we're getting away from the certificates and stuff. So it's, if there's any water transfer fees that are either being charged by the water district or the municipality, or if there's some transfer fee that's a part of the conveyance of the retitling of the water stock or water certificate, then just a bit of cleanup there, nothing really to dwell on. And then down here in association assessment 16.2, we have this current regular. So nothing's changed here. So this is a special and regular assessments. Paid in advance will be credited to the seller at closing. So what that paid in advance means is that, let's say the seller is selling a property and they're in a HOA that collects dues monthly. So in January, they collect the first quarter's dues, all right, for the first quarter, January, February, March. And seller closes on the property. They sell the property on February 15th is closing. Well, in that case, the seller would have already paid February 15th through March 30th dues. Those dues should be credited back to the seller at closing. That should be a debit to the buyer, right? All that says, nothing changing there. All association assessments accrued before closing must be paid by seller, and all association assessments accrued after closing must be paid by buyer. So if for some reason the dues weren't paid, then or let's say that they collect dues at the end of the first quarter for the first quarter. In that case, same example, closing on February 15th. So the association collects dues at the end of the quarter, or the seller just hasn't paid. They're in arrears. In my example, closing on the 15th of February, even though those dues hadn't been paid, the seller should be debited in that case for the 6 weeks, the first half of the first quarter, for the dues that they should have paid. So that's what this sentence is now saying. But anything that accrues after closing, obviously, it's the buyers. It's on the buyers. All right. And then what was deleted here is this reference again to reserves and working capital. Remember, we're talking about up in paragraph 15.3.3 now. We just talked about it up above. Buyer acknowledges that buyer may be obligated to pay the association at closing an amount for reserves or working capital. Again, that's been deleted because there's no reason to talk about it. And that's part of what conflated those two paragraphs quite a bit. And so 15.3.3 is where that should be found. Or that's what's going to control any reserves or working capital. All right, hopefully that is helpful. Possession. Let's see here for possession. The property and inclusions will be delivered to buyer on possession date at possession time, subject to the leases as set forth in 10.6.1. That's due diligence. So if there's a tenant occupying the property, then it's going to be delivered subject to those leases. So your possession, if the tenant is occupying the property, and there's an investor buyer closing on it, your possession is going to be closing, right? You're going to just put that in there. All right. If the parties have executed a post-closing occupancy agreement, such agreement will control possession date and time. So they're now bifurcating leases and post-closing occupancy agreements. As you can see here in the old paragraph 17, or I should say current paragraph 17, leases and post-closing occupancy agreement are treated the same way. So if you're doing a post-closing occupancy agreement, then you could just leave possession blank. You could put NA, because ultimately whatever goes in the PCO document for possession date and time, or the end of the PCO, is going to be what controls paragraph 17 now. All right. So If there's a PCO in place, which there should be, leave it blank. Let me just also emphasize this point. And I've been talking about this a lot this year because it's in my 10 things class. One of the biggest issues I find is brokers who don't get post-closing occupancy agreements executed at the time of contract. It screws things up really bad. I get calls, 3 days before closing from either the buyer broker or the selling broker, or I should say listing broker, saying, oh, we didn't do a PCO. We agreed to do one, but we never executed one. And now, the buyer wants rent and the seller doesn't want to pay rent. Or the buyer wants security deposit, the seller doesn't want to pay a security deposit. Or they can't agree on the number of days or whatever. And my response is, again, you have created a contractual ambiguity, broker. You've allowed, by not forcing the parties into an agreement at the time of contract, I don't know who's right. I don't know if the seller deserves to or is obligated to pay rent or security deposit. I don't know if the buyer deserves to get it. The only person who has that answer is the judge if the parties really want to fight about it. Problem is, it's really a brokerage issue when you allow the parties not to execute one at the time of contract. And the other reason is, as you guys all know, the temperature of the parties, buyer and seller, are getting along a lot differently at contract than they are at closing. So please make it a point to get PCOs executed. It's one of the most common issues that I get on the hotline. Very frustrating. And then this language is added here. Okay, so what this is, there's this dollar per day. So $500 a day. Let's say that's what you put in there. And that means that if possession date and time is possession date and time, and for whatever reason the seller doesn't give possession to the buyer at closing, then it's going to be, or not at closing, I'm sorry, at possession date or time. Let me say that again. If seller doesn't provide possession at possession date or time, then that seller is obligated to pay to the buyer $500 per day, because that's what's in there, or whatever dollar amount it is. Well, this contract never clarified previously whether that was $500 per day was kind of a starting point, and that the buyer could then go, if they had additional damage, which they often do, they could go and pursue additional damages over the $500 per day, or whether it was essentially liquidated damages kind of clause, where that $500 per day was the seller's total penalty for not delivering possession. It was ambiguous in its form. The contract never clarified, and I never really had a good answer when this issue would come up. So we've clarified it now. And it says here, it is not liquidated damages, so that the buyer would be eligible to pursue the seller for $500 per day in my example. Additionally, buyer may pursue a claim against seller for any of buyer's actual additional damages incurred by buyer in excess of that 500. So 500 is a starting point now, and the contract is clear on that point. What does that mean? If the buyer has got a moving truck and 3 movers scheduled for the next 2 days to unpack and move, and now these movers have to move all the stuff into storage, and the buyer's got to pay, a week of storage, and they got to pay a whole new crew of movers to come, and they got to live in a hotel room for a week, and they got to eat meals out for a week because they don't have a kitchen to cook in. They have attorney's fees, they have whatever. All of those things are over and above $500 per day. That's what this sentence now, this is a new sentence. Make sure your sellers, as they're considering, not delivering property on time, address that either through a contract amendment or giddy up and get your stuff out of there. And then you guys see here lines 785, 86, and 87. This is just deleted now because remember, we moved that whole principal residence issue up to the top of the contract. Home warranty there, again, remember we moved that up to the top, so it's been deleted here. Parties, just small cap, that wasn't defined terms parties, that was small cap parties, nothing substantive to talk about there. Termination, this is another clause change that I really, really like. Right to terminate. So this is what it's always said, and we've had issues with it. If a party has a right to terminate, as provided in this contract, the termination is effective upon the other party's receipt of a written notice to terminate. Provided such written notice was received before the termination deadline, right? So if you've got an inspection termination deadline, then as long as the buyer sends a termination based on inspection to the seller or listing broker before the inspection termination deadline, termination is effective upon the listing broker, in this case, receipt of that document, because you as a listing broker receiving something as good as your seller receiving it. And that's always been the case. If the notice to terminate is not received before that, then the buyer, in this case, waives their right to terminate. They don't have a right to terminate. All right. Nothing's changed there. But this sentence was added, and it's important. I'll explain why. Any notice to terminate delivered after the applicable deadline specified in this contract is ineffective and does not terminate the contract. What does that mean? Well, let's say for whatever reason, and this comes up a lot. I get a lot of hotline calls on this issue. Let's say the buyer terminates the contract. The inspection termination deadline is August 5th, today. And for whatever reason, the buyer screws up. They don't get terminated. And then tomorrow, August 6th, the buyer sends over a notice to terminate based on the inspection termination deadline. Well, you as a seller listing broker going, okay, wait a second. I'm entitled to the earnest money, I guess, because the buyer sent me termination. They terminated the contract and they didn't have a right to terminate the contract. Well, this sentence now clarifies that is not the case. What this sentence says is that buyer or buyer broker who sends over a notice to terminate for inspection termination deadline 1 day late or 100 days late, all they have done is sent over a worthless piece of paper that says notice to terminate at the top, but it has zero contractual impact. So if you're the listing broker or seller and you get the notice to terminate for any reason, inspection, survey, any of the contingencies, and it's not timely delivered, then you still have a contract. And so nobody's entitled to any earnest money until you don't have a contract or until that buyer is in default. But they're not in default for late delivery of a notice. They've just wasted a piece of paper and a few minutes of time completing a notice to terminate and sending it over. It has no contractual effect. That's always been implied in this up here, because the whole clause here of right to terminate says if a party has a right to terminate. So the opposite implication is if a party doesn't have a right to terminate, then termination is ineffective. And that's all just clarifying this. But what does this mean? It means that your seller who goes, okay, they sent over a notice to terminate based on inspection a day late. They terminated the contract, so we don't have a contract. Let's get this property released or relisted, I should say, and I'm going to keep their earnest money. Well, not so fast, seller, because what this now clearly says, as it's always been implied, is that you can't relist the property yet because you still have an active contract. The buyer just sent over a worthless piece of paper. Hopefully that makes sense. And then here's effective termination in the event this contract is terminated. It used to be ambiguous. It used to say, and all earnest money received here under is timely returned to buyer. The parties are relieved of obligations. Well, now it's clear. In the event this contract is terminated, all earnest money received hereunder must be timely returned to buyer. So there's one way that a seller keeps earnest money, and that is the buyer is in default. So the only way that termination can occur is because a party's doing it actively because they had a right to terminate, or maybe because they issued an inspection objection notice or any other objection, and then they didn't either withdraw it or resolve it by the resolution deadline. Then the contract terminates itself. But no matter how the contract is being terminated, if it is effectively terminated, earnest money is always going to go back to the buyer. Other than if the seller wants to keep the earnest money, then the buyer needs to default. And primarily the buyer is going to default by not actually closing. All right. So keep that in mind. I think these are good changes and clarify what I thought and have felt for a long time have been unfortunate ambiguities in the contract, but now no longer. Okay, there's paragraph 29. Now, I'm going to try and, if we've got time after I get through the questions, I'll hang on with some of you for a little bit of time. But we talked about this. The video, the YouTube video for my entire thing where I talked about these changes and all the other ones from the other agreements that are changing, exclusive right to buy, sell, broker disclosure to buyer, and the new bar association's compensation agreement. Those are all on a video that you can find on YouTube. You can find it at CAR's website. I don't know if Lisa or somebody can put that in the chat, the link to our little MLS practice changes page, but I've gone over all of that. If the box is checked, see, basically this is really trying to make you make the post-closing occupancy agreement a part of this contract. All right. So now there's no like parties agree to enter into a post-closing occupancy agreement because that was all changed up. So if they're agreeing by checking that there's going to be post-closing occupancy, then it's going to be a part of this contract. At least that's what it says. I know that some of you still won't do it. I know that you'll still do the contract and then you'll wait till 3 days before closing to really hammer out the post-closing occupancy agreement. That's on you in that case. But that's essentially what that says. These are more compensation references above. So basically this is in the broker acknowledgements. Now look here, End of contract to buy and sell real estate. That's it. So these are the broker acknowledgments and compensation section. And basically when it comes to brokerage compensation, they're just referring up to paragraph 29 above, and that's what controls. So that is what it's referring to. I've already talked about it. That's it. I'm stopping my share. I'm in high fear of opening my questions box. Can I just go to the top, Lisa, and see by upvotes? Is that possible? Is that my thing sorted by most upvotes?
Yeah, Scott, if you have it, you can do most upvotes or you can do most recent. Good
Look
luck.
at that. The most upvotes is a commission question. I'm going to answer that last if I have to, because remember, there's questions about commissions. Are we supposed to do is there a date in the contract that the buyer would need to be approved for the solar power lease or loan approval by? I mean, no, there is a date. So the solar panel power plan needs to be delivered to the buyer in connection with the due diligence deadlines. And there is not a contingency date. If that agreement isn't approved, whether it's the day before closing or otherwise, the contract will terminate. Doesn't mean the parties couldn't do an amend extend to change how they're dealing with the solar power plan. In other words, maybe it's the buyer will not assume and the seller is going to pay it off. But I haven't heard of a lot of solar power companies who are screwing up closings by refusing to allow a buyer to step into the seller's relationship with them. Compensation. So we have to check both leased and encumbered. I already answered that. If we are assuming, oh guys, this is so hard to do. If the contract terminates under 2.5, if there's any time, can you address the ability to charge zero rents? Yeah, well, I'll do that right now. I think that's a good question. Yes. Colorado legislature, in their infinite wisdom, passed a bill that says that on a residential lease, if that security deposits on a residential lease are capped at 2 times whatever the monthly rental rate is. And so not exempted out of this are our post-closing occupancy agreements, which are effectively just kind of bad residential leases. What does that mean? It means that if you have zero rent in your post-closing occupancy agreement, 2 times 0 for security deposit is still 0. And so, yes, it's created a problem. I don't have a solution. I've heard a lot of potential ways to trickery around it. At the end of the day, even if everybody signs a PCO with security deposit in place and no rent, if the buyer, landlord, actually tried to retain that security deposit from the seller tenant, I think the seller tenant could certainly go pursue and get that money back regardless of any potential damages. So it's just a function of kind of how things are sometimes when the legislature does things that are a bit heavy-handed. Can a conventional loan pay realtor fees? Yes. I'm kind of talking about. Where is the local health department deadline listed? With the local health department. The local health department controls all of that. So again, if you're doing business in a county and you're holding out yourself as being competent to close transactions there, you better figure it out. And that be by contacting the local county health department, who in the vast majority of cases is who would articulate any county specific rules and deadlines related to septic. Oh goodness. On status letter, would it fall under 7 association and 7 I don't know if I understand that question. On status letter, would it fall under 7 association documents deadline and 7? I don't understand the question. I'm sorry. 16.2. What if special assessment has been voted and approved, but will not be assessed due until a future date? Special assessment that is assessed after closing. Well, so let me clarify this, because this is another common thing. So what does assess mean? Assessed is when the HOA, not when they say, oh, we're thinking about doing an assessment, or gee, we have to do an assessment. Assessment occurs in an HOA meeting when they go, it's on the agenda. We are considering a motion to pass a special assessment. And then you show up at the meeting, and then they call the meeting to order, and they They introduce a motion. Somebody says, I move that we assess every unit owner $10,000 to replace the decks. And then somebody seconds that motion. And then they call for discussion among the board and any other discussion they're willing to entertain. And then they take a vote. And then they drop a gavel and say, approve. That's assessed. It's at that moment. So it's hard sometimes to understand, when we talk about notice and everybody's aware, but if that gavel drops on the assessed after closing, then it's on the buyer. If it drops before closing, it's going to be on the seller. So depends on, but that's how you define assessed. Please define possession versus occupancy. Well, I don't have a good definition. Possession is when you're handing somebody the keys, in my view, which is closing. So at least in our contract, I think you can put possession based on how everything is now written. I think you can, if occupancy is delayed, then remember now the contract, and I've been talking about this here in my 10 things class, the contract, if there's a lease in place, long-term lease, it's an investor buyer, they're buying it with a tenant in place, then you're going to put possession as at closing. Just what you're going to do. Because there's no, that's when you're giving the keys. You're not giving occupancy to, but you're giving possession of the property and all of its obligations, including the lease. And post-closing occupancy agreements in the previous version was treated the same way. But now, again, in this sort of long-term effort to get people to actually get post-closing occupancy agreements figured out and done in connection to contract, if you've got one, you can just leave possession blank. Post-closing occupancy agreement is now a part of the contract, as I showed you in that language, and that's what controls the ultimate possession. And that's essentially occupancy then for your buyer is at the end of the post-closing. I don't know if that helps, but it's never been clear for a lot of people. Check time of day. Oh my goodness, you guys. I'm at the risk of just burying myself and the other attorneys on the hotline. I'm going to say, I'm going to jump back here and do these four most upvoted questions, and then I'm going to call it quits because we're already at 12:01. If I have an existing listing, do I need to modify the commission structure on my listing agreement prior to August 15th? No, not unless there's something fundamental, specifically related to compensation that's changing. If for some reason your client, the seller client, is saying, hey, I'm going to not offer compensation anymore, or I want to reduce it, or I want to increase it, or whatever, you would of course need to update your listing. Other than that, I don't really see much in the exclusive right to sell to update based on the new changes. Obviously, beginning 12:01 a.m. August 15th, those new forms are mandatory. So any form that you enter into after that moment needs to be on the new exclusive right to sell. But there's not a whole lot to update buyer agreements or to update on seller listing agreements. On buyer listing agreements, I will say this. In the event, and I'm happy to address this because it's been a source of confusion. If you have a current exclusive right to buy on the current form with a buyer, August 15th comes and goes. Do you have to update? Yes, if a couple of things might be present. One is your buyer has checked the box, or you have checked the box, buyer is not obligated to pay. Remember, that's going away on the new form. So if you've got that checked, you need to do an amend extend to check one of the other two boxes. All right. Or if you have anything in the success fee, paragraph 7 of your exclusive right to buy, that is not a certain number, a certain percentage or dollar amount. So let's say it's a range between X% and Y%, or let's say it's not less than Y%, or let's say it's TBD. If those are on your current agreements, you need to do an amend extend to put a hard percentage or dollar amount in there on the buyer exclusive agreements. So those will need to be in a much more common situation. There's questions about commissions. Oh, gee. Are we supposed to do an amend extend with the deals that we are under contract very good question again, and I'm happy to answer it. So thank you. Had a lot of these. You got a deal under contract. Put it under contract today. There's no paragraph 29. There's no compensation agreement. You're going to close September 15th, sometime after August 15th. All right. Do you have to update the contract? No, do not update the contract. If you've got a deal under contract now, you have already, under the existing MLS rules, as the buyer broker, you've accepted the offer of compensation because you accept it when you procure the transaction, you procure the buyer. You've earned your commission technically. You're just going to collect it on September 15th. Here's what I would do in that situation. Do not update the contract. No need to. I would make sure that you save, print out, get a hard copy of a screenshot of the MLS listing with the offered compensation right there. And to the extent that at closing on September 15th, in my example, the listing broker, seller's broker doesn't pay you, then you could request arbitration just like you would have now. So no need to, don't disrupt the parties and their current contracts by trying to get amend extends to address your commission. You don't have to. Is exclusive right to sell or in exclusive right to sell, seller has agreed to pay X and give Y to buyer's broker. If the buyer's broker has an agreement with buyer for Y minus 1, who gets the 1? In that case, the 1, good question again, that belongs to the listing broker. Because remember, the listing broker has already negotiated their total compensation with their seller. And that's in paragraph, I think it's 7.1.1.1.1 of the new exclusive right to sell listing agreement. And then 7.1.1.2 is what you're giving the buyer. If the buyer can't or doesn't take that full amount, your seller is obligated to your total compensation. So you're going to want to notify them that, and they may try and get in your pocket. I don't know. That's kind of between you and the seller, but ultimately it can't go to the buyer. So it would go back to you as part of your total compensation, but it is a discussion you probably want to point out to the seller that that's all occurring. Okay, I think this is well, now we're out of order. There are no more dates to terminate, but buyer has terminate nonetheless due to loan issues. They can't buy and must terminate even without earnest money. How, as a listing broker, do I put the property back? Oh, here's the deal. If the buyer, the best way to terminate the contract, if everybody's just willing to come up with an agreement, use just the earnest money release. All right. That document, as it was updated a couple of years ago, it serves as mutual termination of the contract. So if the buyer doesn't have a right to terminate, and let me use this as an example, and I'm sorry, I'm pushing time here. And obviously everybody's free to leave if you want to leave, because I'm getting tired of looking at me on the screen already. So you must be as well. Let's say you've got inspection objection is Monday, inspection resolution is Friday. And in this contract or the new changed contract, nothing's changed with this. We know that inspection termination deadline it can't be delivered after an objection has already been delivered. All right. So buyer delivers an objection on Monday. So they now can no longer use their right to terminate directly. Resolution's Friday. But let's say by Wednesday, your buyer is going, this is not going to get resolved. I want out. I'm done. I can't. So they could send over, and this is where this has come up a lot. One of the reasons we changed paragraph 25. The buyer's agent would then send over a notice to terminate on Wednesday, even though termination was 2 days earlier. And it was their way of trying to express to the seller and listing broker, hey, we're not going to get any resolution here. So here's our termination. Well, remember, termination in that case wouldn't be effective. But what would be effective? On Wednesday, when the buyer goes, listen, we're not going to get through this resolution, the buyer could send over an earnest money release, basically having the parties agree to return the earnest money to the buyer on Wednesday. Buyer sign that, send it to the seller. If the seller signs that, 2 things occur on Wednesday. Earnest money goes back to the buyer, and contract is mutually terminated. So no more contract, seller can put the property back on the market. All right. So earnest money release is a great document to use if you're going to try and accomplish essentially mutually agreed termination versus buyers just notice to terminate. And that's just a notice document, which they have the right to provide notice and create termination by just notice, as long as they still have a date or deadline. If they don't, then they're going to have to use the earnest money release. I hope that answers the question. If not assuming solar panel debt or lease agreement, does solar company then come in and remove who is responsible for damage to the roof? I mean, the seller is going to be responsible for damage to the roof because that's going to be a change in the condition of the property during the contract period. So solar panel gets up there, tears the solar panels off, they screw up the roof. Guess whose problem that is? Sellers, right? Absolutely no questions asked there. But whether or not they will allow for transfer, I think most solar companies are happy to allow a buyer to come in and take over the seller's obligation. They're going to they all have different requirement procedures and background. They're going to want to do their own due diligence on who they're going to be entering into this long-term lease or financing agreement with. But most solar companies are probably incented to go ahead and transfer those. They don't want to come and take off the equipment and pull it off. So basically the due diligence delivery in section 3.1 is not a hard deadline. It's just automatically extended. Yeah, I mean, I think that's one way to look at it. In other words, seller, you've got to deliver this stuff that you've agreed to deliver. If you don't deliver it, then it's going to continue to get extended. And your seller then is in peril of the buyer having termination rights or objection rights that go well beyond what they originally in the contract agreed to. But this is on seller or on listing broker and seller, right? I mean, you got to, dates and deadlines are important. It's a time is of the essence contract. It always has been. Can you ask the forms committee to add a possession time to the PCOA? I used to use, you can, Aaron, because, and I will say this to any of you, I get lots of great comments and recommendations about forms and how to change them and everything else. The Division of Real Estate on their website, right there on the forms page, they have a global suggestion list, I think is what it's called. But you can click right on that. It's a little online fillable form. And, you know, unlike some government agencies where, you know, that goes into the sort of ethos and nobody ever pays attention to it, I can tell you this, Division Director Waters, Marshall Waters, and her staff, and the kind of draft or the kind of chair and vice chair of the forms committee, they look at those comments every single year in connection with changes to be made. So you guys all have the ability to go to that and put in suggested changes. I strongly encourage you to do that. Can we send a copy of this video to a buyer or seller who asks us why they need to use our services? Sure, David. Feel free. They'll be bored stiff by me, but feel free to distribute. It will be on YouTube, as I think was said, probably by today or tomorrow, I'm guessing. I don't want to overcommit, but it'll be uploaded and it'll be available to anybody. Does the loan availability deadline not apply to the seller's lender's approval or disapproval? Would the buyer get earnest money back? No. Again, dates and deadlines, time is of the essence contract, down to the minute. You have until that minute, and that's it. So if at some point the buyer in our contracts is going to assume the risk of something changing with the availability of their loan, whether that's 3 days before closing, 1 day before closing, or 15 days before closing, that's up for negotiation. That has to do with how aggressively you're able as a buyer or a seller to negotiate the contract. But at some point, yes, the obligation or the liability for the lender's non-performance, it is going to shift from the seller to the buyer. And that's what loan availability is meant to be. Under 5.3 credit information, would that include tax returns? No, I don't think so. But I got to tell you something. If you're requesting tax returns from a buyer in order to pre-approve or in order to approve them for their financial ability to buy your property, you've got a lot of cojones. I mean, I don't want those documents. Tax returns have social security numbers on them. So let's say that you as a listing broker on behalf of your seller are receiving from the buyer a copy of the buyer's tax returns, which you would. Guess what you have? Personal identifying information. Well, good luck complying with that statutory framework. It is a beast. So again, I'm pointing out that has been pointed out to me that credit information deadline could be an awfully big hammer for a seller. I don't encourage people to use it. I just don't. I'm just pointing out that based on how the contract currently reads, if you're a buyer getting a counteroffer from a seller that adds those dates and deadlines, you got to understand the implications of what you're getting. Does that infringe on any of the fair and equal housing laws due to being based? I don't think fair housing has nothing to do with somebody's credit information. So no, I don't think so. Pure judgment is the sole subjective discretion, and I think that's all fine. Does the date in the post-closing occupancy need to match the contract, and will they be adding time? No, it doesn't matter. The date in the post-closing occupancy agreement, based on the new change that we have this year, that's the ultimate end-all be-all for possession. All right, so no matter what the contract says now, it hasn't been the case in the past, but it's now, possession is controlled by the post-closing occupancy agreement. So you could put NA in your contract as if you've got a PCOA, which you should, and put NA for possession, and that will more reflect what the contract says is now the contract controls. All right, I'm going to do like 2 more, and then I'm going to let my our CARS fearless staff, and I want to acknowledge the ladies up there, Adela, Caitlin, Lisa, and Holly. Ty said it at the beginning, but these guys do an amazing job. Lisa, it's her member services team kind of, and they really do a fantastic job. So big shout out to you guys. You guys are the best. And this is a heavy lift putting these things on, probably least of all on me, because I just get to stand up here and say stuff. Most of it doesn't make sense, but they have to do all the work in the background. So thank you guys, all of you. All right, 2 more questions. Would this apply if seller leaves personal property behind, big stuff buyer doesn't want? For possession, yes. Possession's free and clear of the seller's crap, basically. And so yes. I mean, it's going to be asked the judge if the seller then has, because how does this all play out? It means that the buyer feels like they don't get possession because the seller's left some stuff there. They're going to sue the seller for whatever per day, unless the buyer just cuts a check and says, "Oh, gee, sorry, I left my crap in your living room." They're going to have to sue in order to get that. And how the extent to which now it becomes an evidentiary thing, like to the extent that a buyer can't reasonably take possession of a property because of this stuff, well, that might all apply. To the extent that they can, and to what degree they could, is going to be more of an evidentiary thing. So, all right, last question, then I'm done. How does buyer go about collecting that per diem under possession? This is what I'm saying. Ask the judge, because ultimately, in most cases, when the buyer finally gets possession and they go, okay, it was $500 per day, you delivered it 6 days late, you owe me $3,000. Well, it's entirely possible that the seller says, "I am so sorry, here's a check for $3,000. If that's what happens, perfect. That's how the world's supposed to work. What often happens is a seller says, "Yeah, I'm out of here, pound sand, adios." Guess what? Buyer has to request mediation because there's the mediation clause. And when they can't successfully mediate it within 30 days, then the buyer's going to go to, in my example, for $3,000, small claims court probably. They're going to sue. They got to get the seller served. They got to go through the process, get a judgment, and then they can go perfect their judgment or collect on their judgment. But it's not a perfect world. And that's why things have to work out how they have to work out. All right, I'm going to call it quits. You guys are awesome. I'm going to reemphasize what I said before. It's those of you who attend this kind of stuff that are going to be prepared for the practice changes and the implications of the changes in our industry. Kudos to you guys for making an investment in your businesses to come and listen to a schlub like me for an hour and 45 minutes now on a nice Monday morning. You're going to be prepared for what you need. Hotlines available 9 to 12, 1 to 4, Monday through Friday. It's a great resource for realtors. And we love hearing from you guys there most of the time, sometimes not so much. But anyhow, thank you guys for being here. We will see you very soon, either in person or maybe on another edition of Legal Bites. Take care, guys.